Good morning. You all know the Urban Land Sealing and Regulation Act 1976 was enacted for the purpose of recovering a land excessively possessed by people and allotting such lands to landless people. Subsequently, what had happened? Then they have repealed Act 1999. It was repealed for the purpose of favoring the very same landlord. In between, a lot of things had happened in Tamil Nadu also. Multi number of lands which were seized under Sealing Act and allotted to Narikoro was scheduled caste people. Even after allotment, they could not occupy that. Multi number of cases are there. A ratio was given here, so the payment, the ratio is pertaining to the implementation of Repeal Act. This is AIR 2026 Supreme Court 475. Dalsubai, Bachubai, Satasia and others. Dalsubai, Bachubai, Satasia and others, State of Gujarat and others. Division Bench Judge B.V. Nagarathina and Justice R. Mahadeva. Multi number of ratios are there. The question was notice issued under Section 10, Subclass 5 under Urban Land Sealing Act to hand over the possession. But it was served to original landowner but not to the appellants who were subsequent to purchaser. So the ratio was acquisition of back-end land in excess of ceiling limit, delivery of notice. Requirement of issuance of notice under Section 10(5) is mandatory and must be issued to the persons actually in possession of concerned land. Then another ratio was acquisition of back-end land in excess of ceiling limit, abatement of proceedings. Landowner, holder of land may claim benefit under Section 4 of the Repealing Act, abatement of proceedings. If de facto possession has not been transferred either through voluntary surrender or peaceful surrender under Section 10(5) of the LC Act, which requires the 10(5) of the ULC Act requires a notice to possessor or a forcible disposal under Section 10(6)(a) of the LC Act. So the legislative intent is that in cases where lands were deemed to have been vested but possession was not yet transferred as on date of enforcement of Repealing Act, lands were to remain in possession of private parties. 3. Subclass 2 of Repealing Act prescribes procedure to be followed in specific type of situations where amounts paid by state must be refunded, but underlying concepts are clear that vesting and possession are distinct and that without later private parties have claim over continuing to be in possession. This is subsequently further emphasized under Section 4 of Repealing Act, under which proceedings abate. Then appellant were in actual possession of subplots at the time of enforcement of Repealing Act. Notice under Section 10 Subclass 5 regarding transfer of possession to state was issued to original landowner but not to the appellant. As no notice was issued to the appellant, there was no transfer of possession in accordance with 10(c) of ULC Act, and it continued with the appellant both in fact and in law. Omission to issue notice to appellant violated mandatory requirement serving notice under Section 10(5) and meant that legal process of acquiring possession was still ongoing, leading to abatement of proceedings under Section 4 Repealing Act on its enforcement. So these all are the most important ratios by which the Division Bench judgment of Gujarat High Court was set aside, and they said that all proceedings are abated on the ground of repealing act. Best wishes.